Hello everyone, today we are inviting the highly renowned international law professor of the Philippines, Professor Dr. Raul Pangalangan, Justice of International Criminal Court. Hello Professor.
Hello.
Nice to meet you.
Well, it's a pleasure. It's a pleasure.
It's a great honor for all of us to invite you as an international lawyer interview. I sincerely appreciate your acceptance of our request for interview from here.
Well, it's my pleasure.
Yeah, okay. We usually begin our interview with a few personal questions. So, would you tell us about your some early days? How about what kind of boy were you?
Born? Far back into the past.
How about your parents' education?
Yes. Well, my father was a law professor himself, and a practitioner, and in the Philippines, and also in his law school, that was the practice that they would be lawyers in the morning, and then law professors late in the evening. And that is what he did. My mother was a full-time homemaker, and I'm the eldest of 6 children. And of the children, 3 of us became lawyers. I have 2 sisters who are, well, I have 3 sisters, 2 of them became lawyers. One is a judge, and another is a partner in a law firm. It's basically an ordinary middle-class upbringing in a suburb of Manila, very quiet place, very traditional Filipino family. Very close also.
How was your education and parents' education?
I think mine is quite typical of Filipinos, especially of that time. I went to a Catholic school for grade school and high school, and then for university I went to the National University, which is the University of the Philippines. The Philippines follows the US model for legal education, which means that we have a first college, first university degree, and then we go to the College of Law for the law degree. I did both of that at the University of the Philippines. And but for me, the most significant part of my education, Eric, is that I entered, we call it UP, University of the Philippines. I entered UP right after Marcos, well, soon after Marcos declared martial law. So it was a military dictatorship, everyone was afraid except UP. And it's sort of, looking back, especially at this age.
What brought you to
looking back, it really shaped the way I lived my life and the ideals.
You were one of the student movement leader.
Yes, I was elected chairman of the student council for the College of Arts and Sciences, the biggest at that time, and also the most radical. And then I was elected president of the law student government.
Have you been jailed?
No, I wasn't, but I have been. I have attended many rallies, protest rallies. I have been hit on the head with police truncheons many times, almost arrested once. Well, once actually already stopped by the police, but the truck which would bring us to the detention center never arrived.
So horrible experience.
Yes, although something I look back to fondly, because people nowadays, people think that it's like the protests against Marcos were very popular and well received. It wasn't. At that time, if you protested, people thought you were crazy. The guy was Marcos was in power. He was feared. Well, he was supported by many people at that time.
At the time.
Yes.
Yeah.
So, but the time I entered the university was the time when the protest movement was very small, not very well supported by others. So it was a lonely fight.
Normal people rather than. So, and what brought you to international studies? to international law studies there?
What brought me to international law? Okay, part of it was intellectual, because I found the teaching and study of law to be so rigid. It was written rules, and very little room for creativity and for analysis. Just a lot of memorizing, which I really found both boring and stupid. This is a freewheeling interview, so I might as well be candid about that. And I found that international law was one area which left me enough room to be, well, an activist intellectually. I like that part. Also, there was the Jessup Moot Court. I took part in that, and I sort of got drawn into this whole international law debates in both within the Philippines and eventually abroad. Yes. So I did international law for my LLM and my SJD at Harvard, and eventually also went for the diploma at the Hague Academy.
Very exceptional experience. And who was your supervisor during your study, graduate study at Harvard?
Okay. For my Master of Laws, for the LLM, my thesis advisor was Philip Alston, and I wrote on economic, social, and cultural rights. And then for my doctoral work, my advisor was Henry Steiner, then director of the Harvard Human Rights.
Human rights. Those two professors, human rights lawyers.
That is correct. In fact, afterwards they became authors of this book, Steiner and Austin.
Steiner and Austin, right. Very famous bestseller of the human rights.
In fact, the approach of the book, I think it is entitled Law, Morals, and Philosophy, or something along those lines.
Something like that.
Actually, I think reflects the approach that I have, that I followed when I was writing the dissertation under the supervision of Professor Steiner, which is to see the law not just as rules, but as the embodiment of moral judgments, of values, and also as a framework, well, to carry out those values in real life, and also to reconcile some of those values in difficult situations, typical of public international law. You've got human rights, but you've got the sovereignty of the state. If the state is a former colony, that state, just like the Philippines, would be so jealous of its sovereignty. And yet, international law and morals as well will dictate that that state ought to respect.
And you're approaching international law from a viewpoint of legal philosophy, something like that.
Yes, that part of international law I really enjoy.
Right, human rights is a legal philosophy.
Yes.
Did you write your thesis in the field of human rights protection, like the ICCP there?
For
your
for the LLM, yes. For the SJD, I would say it was a heavily human rights paper, but it was more about reconciling sovereignty with international regulation.
Oh, really?
Yes. So, which for me is I suppose, the classic conundrum for the field, especially at this time of history.
And still now it is very controversial subject. Sovereignty.
Well, especially for these days, it's a very populist mood all over the world. Populist and also focusing on an inward focus on nationalism against the global trend. So
global governance.
Yes. So I think yes, you're correct, Eric. It is a big debate today.
The current trend is going to the more or less relative sovereignty. So there is some debate between some absolute sovereignty and relative sovereignty. So at the time you touched on this kind of problem, the sovereignty within international regulation. Am I right?
Yes. The interplay.
Yes. Interplay. Right. And after coming back to Philippines, you're studying as well as practicing law, and it's quite exceptional some situation. Someone is doing research as well as practicing law.
Yeah.
And how do you think you could just coordinate these two different areas? And
Oh, well, my short answer, Eric, is with much difficulty. Because, in fact, you know, Eric, let me take 2 steps back. The assumption back home in Manila, really, is that all professors will have to engage in some practice. In fact, we are the only law school with real full-time scholars teaching. There might be a few others with some full-time faculty, but we are the only ones known to have a predominantly full-time faculty and dedicated to their field and doing some theoretical work. But going back to your question, Eric, on how to combine, for me, the most, how should I say this, strategic measure is to make sure that like in my case, I did public interest work as a lawyer, and I taught public law, which is constitutional law and public international law. So my academic work blended with my practical work, and the practical work also helped my academic work.
So would you tell us about the most impressive case you have argued as a practitioner?
Well, I will single out, in the Supreme Court of the Philippines, David versus Arroyo. That is, David is the leading public intellectual in the Philippines, sociology professor at UP. The president, Arroyo there is the president. She declared a state of emergency, and the first person she arrested was Professor David.
The first professor who was arrested by that.
Yes, it was a big mistake.
State of emergency.
Yes, it was a big mistake for the government. In fact, they realized that a bit too late. On the day of the oral argument before the court, actually, Eric, the area of the court had lots of security, police in case there were like protests. Well, of course, that case is now in the law books, and it's part of history.
Wow. So, and then 2 years ago, you went to The Hague, joining the Department of International Court of Justice. And what is the main cause, and what is the main factor that you decide to go there?
Okay. In fact, Eric, I'd like to go back. I actually took part in drafting the Rome Statute.
Yeah, right.
But, you know, it's hard also to explain, Eric, to the current generation of students. They know that an ICC exists. They know that there are many international criminal tribunals. The Yugoslavia Tribunal, Rwanda, there's the Khmer Rouge court in Phnom Penh. But, you know, looking back, when I was a grad student at Harvard, and I will walk through my Carol as a doctoral student was in the international law section. So I walk through all those books every day. The only one person was writing on international criminal law that whole time, Professor Sharif Bassioni. And when I would read his books at that time, I would ask myself, will it ever come to pass that there will be an international criminal court? Because there was no interest. We were at the tail end of the Cold War. Nothing was moving in that direction. The last international criminal tribunals were Nuremberg for Europe and Tokyo for Asia. And afterwards, the whole field was frozen. So in the late 80s, when I was studying at Harvard and I would see the books of Professor Bassioni, you know, I would have this feeling, first, that I'm so glad there are professors, scholars who will take on a cause when no one else wants to listen. I think that my favorite metaphor is from Victor Hugo, an idea before its time has come.
Ah.
Because the flip side is, he says, there's nothing more powerful than an idea whose time has come. So before the time came for the ICC, there was one professor writing about it,
Oh, really?
who kept the lonely crusade. But that's the thing also with ideas, Eric, in our life as professors. Before we knew it, there was the Yugoslavia conflict. There was the Rwanda conflict. The world, the Cold War was over. The UN Security Council could flex its muscle and said, well, part of the post-conflict measures is to establish a court. And before we knew it, that was the early 90s, apparently the world felt that by 1998, it was time to have a permanent standing fully international court. Not just an ad hoc court, like Yugoslavia, not for a specific dispute, not created after the fact, but a court that will be standing and ready to receive complaints or cases as they arise. And so in '98, when I took part in the drafting of the Rome Statute, I still was not convinced that there will be actually a court. I still recall the last evening of the Rome Conference to draft the statute. There was the voting, and this was held at the big plenary hall of the FAO, Food and Agri.
Wrong.
Yeah, in food and
agricultural organization.
Yes. Okay. And the voting was, you press a button and then a light shows on the wall. And it was a long evening because every state would have individual voting, explain its vote. And it was late in the evening, and people, I think, lost track of who voted for what. Because it's individual voting by 100 or so states. But when the chairman said, we now call for the votes, and they pressed the button, we were actually amazed. Hey, it's all green, except for a few red lights. The green was a go. And
unanimous.
And we had, not really unanimous, there were a few. Yes, and we actually looked at one another and we said, so we have a statute, huh? And we just broke into applause. So I think, I do hope it's an idea whose time has come, and that the experiment will bear fruit. But I emphasize the word experiment. This is a very early stage in the life of the court. And we are just, we're just 15 years into our existence. And out of those 15, I think it took a number of years before the first case was filed. And so I think if one looks at the history of these tribunals, this is a very, very early stage in the life of the
court. So as one of the founding members of the ICC, you drafted Rome Statute, and you're now just realizing your dream, you're practicing law in that course. So you have been there for 2 years.
I have been, yes. So 2 years this month.
This month, right. Yes. How about your first impression for the past 2 years? As a judge, as an owner.
Again, people assume that this is an international criminal court, that there is such a thing as an international criminal law field. Not quite. At this stage of the life of the court, it's a very young court, a very young discipline, and therefore people come into the field either from international law or from criminal law, which is very domestic in character. So really these are two entirely different fields. And different cultures as well. And not only that, we are 18 judges elected by roughly 125 countries, and we come from both, some from the civil law tradition, from the common law tradition, and these approach criminal law in entirely different ways. So, though the common ground is public international law for the framework, for the relationship between the court and the member states, for complementarity, the day-to-day working of a court is, I love to remind people, to determine whether the accused is guilty or innocent. And that is almost a straightforward criminal law, handled by prosecutors and defense counsel. They handle the evidence that's presented before the court. I have sat on, I am now on my third case that I'm handling, third trial that I'm handling in the court. I've handled other, I have been assigned to appeals and other cases. So if you ask me about my impression of the ICC, this is I will say that this is a court which is trying to combine the best of all traditions, of civil law, common law, and of course public international law, and make it and to make it work. I have discovered the complications in the course of trials. An innovation of the ICC is victim participation, and people applaud the ICC for that. But you know, it complicates the proceedings. It's a very difficult question. The court must do it. It's part of the charter. It's part of the mandate, and it's also part of the philosophy that the goal is not just to punish the guilty. The goal is to help the victim communities recover.
Yeah. Okay. 괜찮은데 나도.
I can go on and on. Okay, have you stop me? I'm okay. Should I also look at the camera every now and then, or just you? Should I?
It's okay.
Anything.
Yeah.
Okay, so today there are many disputes between states, especially in East Asia, and a lot of some political and the economic some conflict and dispute, and of course some it is some of them are escalating into military clash. So, and there was a prominent court of arbitration award on the South China Sea, some conflict between the Philippines and China.
Yes.
And in your opinion, do you think can East Asian countries be rule-based society, something like that, under international law?
Okay. You referred to the case between the Philippines and China before the Permanent Court of Arbitration, and I am so glad that the Philippines chose to settle the dispute through law, and by submitting to a neutral and impartial tribunal and a fully international proceeding at The Hague. And I think it is a good sign for Asia that Asian countries have recourse to international adjudication to settle disputes. But on your other question, Eric, about the prospects for rule-based conduct of relationships among Asian countries, I think all over the world, if you will compare attitudes to the rule of law or attitudes to third-party adjudication, Asia is one of the weakest. It's nothing controversial. It is, in fact, one packaging of the argument is labeled the Asian values argument.
Yeah, Asian values argument.
So, for me, the best way to strengthen the rule of law internationally especially in Asia, is to strengthen the rule of law domestically. In other words, Asian states cannot appreciate the role of law abroad until they appreciate it domestically, in day-to-day life. And the flip side is also true. If locally the courts are not independent, that country will think international courts are not independent. If their local courts are corrupt, they think international courts are corrupt
too.
If they think that their local prosecutors are so political and will just follow the orders of the president or of the governor, they will also assume that the international prosecutors are like that. It's like, I think in psychology they call it projection. What they see in themselves, they see in others. So for me, I think they have to be told, they have to be taught actually, that it is possible to have real separation of powers. It is possible to have real independent courts and independent judges. It is possible to have prosecutors who decide on the basis of the facts and the law, and not on the basis of what their superiors tell them, or what the newspapers will say, or what the bloggers or the social media will say. I think it is, in some countries they think it is impossible to have that. What I have seen in the ICC is that the separation of powers between the prosecutor and and we call them the chambers, the judges, the trial chambers, is very strong. The independence and non-political character of judges and prosecutors is there. So I think we have to educate people in Asia about the role of government institutions and justice institutions. And then maybe if they see that in day-to-day life, they will appreciate that it's actually possible to have a genuine international adjudication for their own disputes.
So in that sense, international law is not very popular in Asian countries. There is a reason, I think, there we have experienced colonization, a lot of civil conflict inside domestic society, but now it's global community. They get some melting together and there is a lot of fusion between the values of each society. So I think the role of international law will be more important than before. But in Asia, unfortunately, the international law is not working very well, right?
Yeah.
So can you just give some proposal how to promote the international law in the academic as well as practical perspective?
That's a nice question, Eric. You know, the way I do it in the Philippines is to remind, to use in my cases, in my courses, material from Asia. In other words, if I want to teach international criminal law, I will tell my students, of course, about Nuremberg. You can't skip it. It's the biggest event in the field. But I tell them there is such a thing as the Tokyo War Crimes trials. I tell them that there is such a thing as the Khmer Rouge Tribunal. In other words, if I will teach something in international law, hybrid courts, I won't use the hybrid courts in Europe. I will use the hybrid courts in Asia. If I will discuss truth commissions, these exist all over the world. We have truth commissions in Latin America, in Africa, but I will use truth commissions in Asia, like in East Timor, for instance. So that Asians don't think that international law is something done by Europeans or by Americans. It is something which is alive. In Asia.
In fact, everywhere in the world, not only
Eric, even if you look at territorial disputes, you mentioned the Philippines-China dispute. many countries in Asia,
Mm-hmm.
including Southeast Asia, have gone before the ICJ or before some arbitration bodies to resolve their disputes.
Mhm.
And for me, it's not as if it's only other continents which use international law. We actually actively use it.
Right.
It's a matter of telling people.
That's right. Yes.
Or it's a matter of making sure that, especially the youth, realize that some of the things they enjoy today, like for instance, the people don't realize that many of the things they buy in the stores today wouldn't have been available had it not been for the WTO. And well, of course, conversely, there are bad things as well. Our agriculture is suffering because of cheaper vegetables from abroad, and I think vegetables are the one thing which a poor country like the Philippines should produce locally. But still, you're asking about how to make Asians appreciate international law. For me, it is to expose them to the full range of international law matters which are day-to-day dealt with
That's right.
in their jurisdictions. I did once a study on Philippine domestic law decisions using treaties, international treaties. Oh, there's a wealth of these decisions, from human rights to people getting bumped off in airplanes who want to file cases under the Warsaw Convention. There's inter-country adoption for children. So it's the full range.
I fully agree with you. Don't you think we have to more focus on the currently ongoing critical pointed issue, because we are facing a lot of some problem and common question before our own situation. So, but for example, there is a conference of Asian Society of International Law, which is now upstairs. But
yes,
unfortunately, I don't find any critical pointed issue that we have to deal with, like territorial disputes, something like that. But they are just dealing with and discussing very general trends, like international human rights law in an Asian perspective. Like that's why the people don't.
I saw two panels just for the South China Sea, South China Sea decision. I haven't reviewed the entire program, but I think if you're looking for specifics, that is one very specific topic. Well, for me, there will have to be a balance anyway.
But this is, I'm sorry, but this is kind of interpretations, South China Sea problem.
Decision, yes.
Yeah. But for example, we have some question like North Korean nuclear problem and the Indian-China national border conflict.
Yeah.
A lot of problem and some question of past history between Korea and Japan, and China and Japan. A lot of some trade conflict, investment conflict between China and Korea, things like that. But they never ever.
Okay, so you're saying that
kind of
the topics are more thematic. So
right? Yeah, there's
big issues.
Big issue, right? General trend, right? It's just
That's very
international.
That's interesting. But maybe that's the Asian style also. If people will disagree on specific issues, they'd rather talk about the Asians.
Just we
prefer to talk about the big.
So I don't like the I don't like the word sentence Asian perspective.
Oh,
if we just talk about some very current issue, that's Asian perspective because we're Asian. Imagine that what European lawyers did in this kind of conflict 200 years ago.
Yeah.
I think I'm sure they were harshly talking about what they were doing.
Yeah.
How to colonize, how to expand their market in Asia, how to coordinate armed conflict in the European conflict, something like that. So
maybe it's part of the historical pattern. When they sat down to draft the rules of international law, they didn't say that this is the European way of doing things. They just simply said it was the right way to do things. But anyway, and for us, we have to distinguish ourselves from them. And maybe that's why, I'm just trying to speculate, maybe that's why there is a so-called Asian way of looking at things. But yes, I do agree that we should, it is best to debate these issues and just on the issue, you know, to debate, let us say, the interpretation of a certain treaty.
right, the more we are abstract, the more we will be isolated from the current society.
Well,
I think it's very important.
yes.
So our journalists every time always to just trying to find and pinpoint the most critical and current issue that we are obliged to tackle.
Yeah.
It's the most important assignment for our lawyer to do for the society. It's a contribution. So.
Well, for the current big issue that I'm most familiar with, which is the South China Sea issue, we call it the West Philippine case.
West Philippine
Issue, I think it has been well studied in the journal, including your journal. The journal has had excellent articles. Well, including articles not necessarily similar to those of the Philippine position, but as an academic, I read them with interest. The Taiwanese articles were excellent, I think this is part of the process that you mentioned, of making sure that the international law experts in Asia should really discuss these things.
Yeah. So we're coming back to a personal question. Have you ever had any difficulties in your life, because your life is very successful and most of the young international lawyers are their life role model? But I'm wondering if you have any difficulties. If so, how did you overcome these difficulties? It's very important, for young generation. So many young generation nowadays are frustrated by those difficulties.
Yes. Well, actually, Eric, when I noticed that my former students or young faculty members would like to do what I have done, I advised them that, what I did was a bit difficult, and I have just been really lucky. I have been very blessed to have all these opportunities. So in fact, I have to be careful. I don't want to discourage them, but I want them to come into this path with their eyes wide open, so to speak. Specifically for the Philippines, the real pressure is that I think the way of thinking back home doesn't really appreciate scholars and professors and specialists. It's a very practical culture. And so young people, young lawyers are expected to go into a field which pays a lot, for which there are many income-earning opportunities. And the real danger is that one can, how should I say this, practice law to earn a living, very practical field of law, maybe commercial law or something, and then go to the university and teach something esoteric like legal philosophy or constitutional theory.
Jurisdiction.
And I chose not to do that. because I felt it might be very difficult for, it's not really for the mind to adjust. For me, it's for the soul to adjust, because you're shifting from two different worlds which think differently. One field where the highest virtue is profit-seeking.
Profit.
Yeah, and the other world where the highest virtue is
Justice.
justice, yes.
Right.
So for me, it's that adjusting to a culture. I mean, you were away studying abroad for a long time. I imagine coming back, you needed to adjust all over
Sure.
again.
Yeah.
And the same thing here. I came from a place where every legal issue was seen as a question of morality or social preference of social justice. And then I go back home, and the first instinct, if you look at a legal issue, is how do I get away with it? Or how do I justify it for whoever will pay me, for whichever side pays. So it's the adjustment which is for me difficult, and of course the way you live out the adjustment in day-to-day life. I can give you a very practical demonstration, Harry. In the Philippines, all lawyers are addressed by the title attorney.
Oh.
It is unique to us. So it is ATTY, period. Attorney.
ATTY.
Yes. And that is why in the Philippines, even professors of law and deans are addressed as attorney.
Surely.
Except in my law school, we are dean and professor there. So I know that I come back to a country where people think it is better to be called attorney than professor. And I will live with it. I am attorney Pangalangan. But in my heart of hearts, I am professor.
Professor, right.
I mean, that is my life. I teach, I read, I write. But I also know that in that culture, people prefer me to be attorney Pangalangan. And even waiters, yeah, police, whatever, you know. Whenever I go around, they like the attorney to be around.
Yeah.
It's like doctor.
Delicate, different of nuance.
Yeah,
and in connection to the culture.
yes, and of course when I go abroad and attend a conference, I am suddenly Professor Pangalangan.
Yeah.
So, you know,
When
of course.
I joined my university just 13 years ago, my dean tried to just call me doctor rather than professor. So I was quite curious why he was referring to me.
That's
as doctor.
interesting. That's very interesting.
Because when he became professor, not all the professor had doctoral degree.
Yes.
So it's kind of honorable.
It's better.
Better than professor.
Yeah.
Doctor is better than professor.
There is something like that back home as well.
Right.
Something like that. And then I have to explain again to friends back home. You see, in some places, they would actually prefer the title professor to doctor, and leave the title doctor to physicians. But you know, it's maybe also it's an Asian game about titles. But
title is not important. Title
yes,
is not fundamental problems. So,
yes. But I gave the example of titles only to demonstrate the cultural difference.
To some extent, nuance.
That I come from. You know, in fact, it is so. The Philippine culture is so different from what I have seen in the Confucian societies, where the scholar is, you know, a respected guy.
That's okay. I'm Mr.
And I thought it was just the Confucian societies who had a special place for the scholars. But I moved around in Asia and I realized, hey, professors in other parts of Asia are also have a special place. In every place except my country.
One last question. there are many young international lawyers who are admiring you in
Well,
this
you're too
campus
kind, you're too
side. This is fact. So would you give them with some piece of wisdom how to get to your level of this professionalism?
Well, first of all, you're too kind, Eric. But let me, since I usually give advice to my students, for me it's this. As with any profession, they have to equip themselves with the basics. First, the degrees. It's useful to have a master's or a doctorate, because they will be competing with other young scholars from other countries who have these credentials.
Yes.
So basically they have to speak the same language. And that's the first, to equip themselves with the, to publish extensively, to take part in these international meetings, to take part in moot courts. Because I think especially from Asia, because we tend to be isolated from, well, Philippines anyway, from outside, and we don't realize it is an eye-opener if they go to a moot court where all of them came from different places, but they will deal with the same case problem, and they'll slug it out like as equals, as peers in the battlefield.
Yes.
So for me, it is that sort of preparation which will give them the credentials.
Credentials, right? Diploma.
Yeah, the diploma, the
Credentials, diploma, right?
the learning, the exposure,
Yeah.
and for me, the network, the friends.
Yeah. Sure. Connection.
And I think especially with the ease of with the internet nowadays, they can actually easily exchange notes among one another to find out good things happening elsewhere. And my last bit of advice is not to over-specialize too young. Because I don't think there was any point for students in the 1990s, well, maybe the late 80s, to say that we will prepare for international criminal law, because there was no criminal tribunal, international criminal tribunal at that time. So if they prepare themselves for careers which are available just when they're studying, they don't realize that maybe 5 years, 10 years down the road, there will be other things which might be more active and for which there might be more opportunity.
World is changing.
Yes, or more issues that will arise. It would have been difficult to anticipate some issues that we face today, and there will be more such issues in the future. So they should be prepared. But I'm happy when I see my students enjoying their studies and their careers. I think it's part of the joy of a professor to see once students have all these adventures, to bump into them in conferences or in beautiful places in various parts of the world, and all of them doing interesting things.
Yeah. Wow. So yeah. I'd like to just listen to more time, but you have limited time available.
Oh, it's always a pleasure to speak to you, Eric. It's always a pleasure.
I think we have to just stop our conversation here, and I hope we have another chance to talk about more current and sensitive issue. And thank you very much for your most impressive answers to my stupid questions.
Not stupid at all.
Thank you.